Welcome back. We're now beginning the second half of our course on America's Constitution. Having focused on the written Constitution in the first half, we're going to be focusing on America's unwritten Constitution in the second half of the course. And maybe for some of you, them's fighting words. What do you mean, unwritten Constitution, Professor? I thought that you were always waving around that copy of the written Constitution and telling us that these 8,000 words anchor the entire constitutional project. And that's right. That's what I did say. That's what I do believe. That's my story. I'm sticking to it. These words in the written Constitution do anchor the constitutional project, but we're going to need to go beneath, beyond, and behind them in order to fully be faithful to them, to do justice to these words. These words, for example, don't contain a set of instructions about how the Constitution is to be interpreted, a complete set of instructions. And you might say, well, Professor, they don't, but the English language does, and just read the words. The words, all the words, and nothing but the words, you might think. Okay, but the words don't say the Bill of Rights, and yet it maybe is useful to talk about the first 10 amendments as a package. The words don't say separation of powers, and yet that might be a very useful way of thinking about the architecture of the document as a whole. Articles 1, 2, and 3, separate articles vesting separate powers, legislative, executive, and judicial, respectively, in separate branches. But you won't see that phrase, separation of powers. You will see it in some state constitutions, but it's not in the U.S. Constitution, nor is the phrase checks and balances, or the phrase limited government, the rule of law, federalism. Now, all these things I submit are obvious, essential parts of our constitutional experience, but you won't find them in so many words in this terse text. Now, you might say, okay, there obviously is a need to sort of imply certain concepts, like separation of powers, checks and balances, limited government. And I would say, fine, but where does it say we get to imply stuff? That's itself an unwritten idea. And you might say, well, but these things sort of supplement the written Constitution, but we could never take anything away from the written Constitution. And I would say, fair enough, but when you look at the written Constitution itself, sometimes its words, read narrowly and literalistically, are a little problematic. They may not actually make sense in light of the constitutional project as a whole. A simple question, I'm going to come back to it at the end of this lecture. Simple question. Who presides at the Vice President's impeachment trial? Because if you read the words of the Constitution, sort of literally and narrowly, the words say that the Senate tries all impeachments. It's the court of impeachment. And the Vice President presides over the Senate. And there are a couple of exceptions that are mentioned, but there's not an explicit exception when the Vice President himself is the impeachment defendant, is charged with having committed a high crime and misdemeanor. So the text doesn't explicitly make an exception when the Vice President is himself an impeachment defendant. So if you just read the words, the whole words, nothing but the words, it might seem as if the Vice President presides at his own impeachment trial. But can that be right? Is that what the Constitution really says, rightly understood, when we understand the proper rules of legal interpretation, which I'm going to argue have to go beyond narrow literalism? Take the First Amendment. It says freedom of speech and freedom of the press, but it says Congress shall make no law abridging freedom of speech and of the press. Well, what happens if the president starts messing with freedom of speech with a censorship edicts, or if federal courts try to shut down freedom of speech and the press on their own motion? What if states try to suppress free speech? If it's just about the words of the First Amendment, the words and nothing but the words of the First Amendment, was the first Congress free to suppress free speech, at abridge free speech and free press, because remember, the first Congress in the first few months under the Constitution, the First Amendment hadn't been adopted yet. So before the First Amendment came along, was Congress free to do these things? And after the First Amendment, what about presidential censorship or judicial censorship or state censorship? So if it's just the words say someone can't be put twice in jeopardy, well, what about 3 times? The words say you can't be put in jeopardy of life or limb, but what happens if they're not going to try you a second time and hang you, take away your life, or dismember you, take away a limb, but just put you in jail for the rest of your life? Hard labor. Because the words say life or limb. And by the way, the words also in the Ninth Amendment say that there might be unenumerated rights, unlisted rights, rights that aren't textually specified. But the Ninth Amendment, so to take that seriously, those words seriously, I suggest we're going to need, in effect, to go beyond textual literalism. But the Ninth Amendment doesn't tell us explicitly, in so many words, how we have to find these unenumerated rights, which it suggests might be out there. I'm going to argue that actually we have more rights than the text explicitly lists and enumerates, never less as a practical matter, and we are being faithful to the Ninth Amendment when we add rights to the Constitution in various ways. But there are rules for that game. It's not all. It's not that all bets are off. That judges or other interpreters can just make stuff up and just call it the Ninth Amendment. So the Constitution's text, I'm going to argue, itself invites supplementation in various ways. It presupposes in all sorts of ways an unwritten Constitution that completes it, that makes sense of the larger constitutional project. So here's the challenge. The Ninth Amendment seems to suggest we need to go beyond the written Constitution. I've given you some other reasons for thinking so: the language of the First Amendment, the absence of concepts like separation explicitly separation of powers, checks and balances, the rule of law. I could have said, doesn't say one person, one vote, doesn't say separate is inherently unequal. So where do we get these bedrock principles from? Because it's not necessarily from the words simply read literalistically, and yet many of these things, I'm going to argue, are not merely uncontroversial today, accepted by judges on both sides of the aisle, by Republicans as well as Democrats in the political branches. It's not just that they're widely accepted, but that they're correctly and properly accepted. That, in effect, today we are all textualists and we are all living constitutionalists of a certain sort. There really are ground rules for this project, and the second half of the course is going to be to try to show you what those ground rules are. They're ground rules of interpretation. There are a variety of techniques, not an infinite number, but a variety of techniques and tools of interpretation through which we can go beneath, beyond, behind the written words, while still remaining ultimately faithful to a written Constitution, its deepest premises, while basically, so there are going to be ways of supplanting the text without ever, supplementing the text without ever supplanting it. There are going to be ways of finding this unwritten and deploying this unwritten Constitution in a way that ultimately vindicates the written Constitution. That's the challenge, because not everything that is beyond the written Constitution is in fact faithful to the written Constitution. So the way we're going to organize this half of the course is quite different than what we've done so far. What we've done so far is walk through the written Constitution, article by article, amendment by amendment, and now we're going to actually organize things differently. The biggest part of America's unwritten Constitution is basically the rules for interpreting the Constitution. Because remember, the Constitution doesn't tell us in exclusive and in exhaustive detail how it is to be construed, how it is to be implemented. There are various tools and techniques for doing for implementing and construing the Constitution. Textualism is one of those tools and techniques, and we've already done a fair amount of textualism, and we will continue to do that. But there are other tools and techniques, and each chapter of the book, America's Unwritten Constitution, the book that's going to anchor this second half of the course, each chapter of this second book introduces you, the reader, you, the audience, to a different tool or technique of constitutional interpretation that goes beyond a literalism but is nevertheless properly lawful, faithful to the constitutional project, is something, in fact, that judges and lawyers of all stripes, from all parts of the political spectrum, do in fact do. Whether they admit it or not all the time, they actually do it. They accept these tools and techniques. They are the proper kit bag of the constitutional interpreter, even though these tools and techniques are not themselves explicitly mentioned in the document. So that's what we're going to do for the second half, is identify these tools and techniques, and I'll give you examples, applications of how these tools and techniques are properly applied, and also sometimes give you examples of what would go too far, what you can't properly just read into the Constitution or supplement, because you can't just make stuff up and call it the Constitution. There are going to be rules to this game. Now, let's take, for example, freedom of speech, since I mentioned the First Amendment. We can find that in the First Amendment, but if we just focus on the words, it just says Congress, doesn't say anything about the president or federal courts or states. Those words materialized in 1791 when the Bill of Rights is ratified, the First Amendment is ratified, but I'm going to claim that even in 1789 and even in 1790, before those words were adopted, there was a deeper free speech principle that was even broader than the words of the First Amendment. And I'm going to show you actually that this idea of free speech can be found in several components of our unwritten Constitution. One chapter, the first chapter, I'm going to teach you a technique about reading between the lines, reading the Constitution as a whole and appreciating its structure, its architecture. The Constitution's about a system of popular self-government, and that system presupposes that ordinary people, we the people, can engage in a robust, uninhibited, wide-open freedom of political expression. Government works for us. They are our agents, our servants. We are the masters. We are sovereign, and therefore, in order to be sovereign, we get to talk amongst ourselves and trade political ideas, and they can't shut us down. Not Congress, not federal courts, not presidents, not states, and that's true even before the First Amendment is adopted, because the basic constitutional project, when you read the document as a whole, is about free and fair elections and popular sovereignty, and those things make no sense unless the people have robust, uninhibited, wide-open freedom of political expression. It's a structural argument. That's one way of deducing free speech. Now, in a later chapter, I'm going to say, look, here's another argument for free speech. Forget about the text for a moment. Let's look at actually how the Constitution, in fact, came about. And it's more of an historical argument, how it was in fact, indeed, ordained and established. And it was established with an epic exercise of freedom of speech. Even before the First Amendment came along, there was the freedom of speech that was baked into the constitutional cake, because the year that changed everything, the hinge of human history, that year 1787-88, where we the people did ordain and establish the Constitution, well, we did that through free speech. Free speech was part of the very process by which the Constitution becomes law. It's part of our Constitution, not just when we look at the words holistically, the architecture of the whole thing, but when we look historically at how the Constitution was, in fact, ordained and established. That's a different kind of tool or technique than holistic reading. It's a little bit more historical. How, in fact, was the Constitution adopted, enacted, if you will? How was it amended, and what principles were big and necessary, important components of that enactment and amendment process, and therefore baked into the constitutional cake? Now, here's yet another way of thinking about an unwritten Constitution. Let's think about the Ninth Amendment for a minute. It talks about unenumerated rights. It talks about rights of the people. Well, how do the people actually manifest their understanding of, their belief in certain unenumerated rights? Well, one of the ways we, the people, manifest our understanding of rights is just by living them out day to day, how ordinary people live their lives, and they live their lives with freedom of speech. It's part of the custom of America, the tradition. That's a kind of a Burkean argument. The English philosopher and parliamentary leader Edmund Burke talked about basically the folkways and the customs of a people. And the Ninth Amendment tells us that not all rights are enumerated. One source of those rights is going to be custom, tradition. Free speech is a very important part of America's lived experience on the ground, day to day. We do all sorts of things. We live our lives freely, in part through free speech and free press. Well, here's yet another technique. We have to read the Constitution not just unaided by just examining the document. We sometimes read the Constitution through the prism of case law. The Constitution itself talks about the judicial power in Article 3, and Supreme Court cases in particular play a particularly important role in our constitutional project. And I'm going to offer some ways of thinking about the relationship between case law, between precedent, and this terse text, the document itself. But when we look at case law, we see again and again emphatic affirmations of freedom of speech and of the press. In iconic cases like New York Times versus Sullivan, that today every justice on the Supreme Court, left, right, and center, pledges allegiance to. So I've given you already a few different, I've foreshadowed a few chapters of the book, different techniques and tools, and shown you how free speech is going to be an application in various, an application that we can see using various of these tools and techniques. Reading the Constitution as a whole, Chapter 1, seeing how the document was in fact enacted an amendment over time, Chapter 2, paying attention to the lived customs and practices of ordinary Americans, how we just live our ordinary lives. Free speech is a part of that, Chapter 3, paying attention to case law, to precedent, which is an important component of the American constitutional project, Chapters 4 and 5. And free speech is going to pop up yet again in later chapters. So this part of the course is organized around, to repeat, the tools and techniques of constitutional interpretation that go beyond textualism, but ultimately try to fit with a careful attention to the written Constitution properly understood. Now, as is a tradition in this course, I have an image up on the screen. And I just want to sort of end by telling you a little bit about this image. This image is the image of the companion book to the one that we've just summarized. The first book that we covered was America's Constitution, a biography. The sequel is called America's Unwritten Constitution. It's not required at all, but if you want to get more depth of understanding, because there's only so much we can do in this online experience, I recommend the book. It's available at bookstores and online and in libraries. I think the hardback runs about $20, and I hope it'll be out in paperback soon, maybe even for something like $15. It tells you basically what it's about, America's Unwritten Constitution. But here's something I want you to notice. If you actually just read it using the standard rules of English from left to right, actually here's how it reads. America's, the precedents, unwritten, and principles Constitution we live by, which is totally garbled. Okay? Here's how we just read it. We read the title, which is in one font, America's Unwritten Constitution, and then, in effect, we see the subtitle if we read more carefully, the precedents and principles we live by. And that's because the different fonts here are actually signaling to you, the reader, that there's more meaning here. There's sort of levels of coded meaning just beyond the straightforward read left to right, top to bottom. And in fact, the subtitle in particular, I want you to notice, is, in effect, between the lines, the precedents and principles we live by. So this is a reminder that There are all sorts of levels of meaning, of proper meaning, that can't necessarily be deduced merely from the most narrow and literalistic analysis, but that are nevertheless there, are supposed to be there. You would read it the wrong way if you just read it this top to bottom, left to right. You would read America's the precedents, unwritten, and principles, Constitution we live by. But once you understand that one of the many tools and techniques is to read between the lines, you will see that this book is America's Unwritten Constitution. In effect, colon, even though the colon isn't written at all, America's Unwritten Constitution, colon, the precedents and principles we live by. And in fact, our first chapter is going to be about that particularly interesting technique. It's a technique of reading, and therefore of textualism, but reading between the lines, not just reading word by word and clause by clause, but more holistically. That's what we're going to do in the next couple of lectures. Here's what I'd like you to do to get ready for that one. Ask yourself a simple question. Who presides at the Vice President's impeachment trial?